Now we get a chance to look at one of the most interesting constitutional law hypotheticals you're likely to see. Here is a con law question that, at its core, is a remedies question. One point that I make from the very beginning of these seminars right through until the very end is remedies is the heart of just about any bar examination in the United States. And the reason I offer this idea is plaintiffs always want something. And being able to explain exactly what it is they want and to give a clear answer about whether or not they should get it is one of the key skills that all lawyers need to have. Now, as always, we'll take a look at the call of the question. It says, what rights arising under the United States Constitution should ANI assert in its claim for relief, and how should the court rule? Discuss. Well, it's a very clear call of the question. We know who the plaintiff is, and we know that we are being asked to think up constitutional law theories, and also we know that there are claims for relief. So we'll take a look and see what those claims are and try to figure out whether or not the plaintiff is entitled to them. This is a difficult question, and it's quite a subtle question. It's unlikely you'll see constitutional law questions more difficult than this one. And you also are likely to see questions similar to this on the multi-state bar examination. This is a hard question, and it is a very interesting and instructive one, to the extent any of these questions really are interesting. All right, go to the top of the question, and we find out about the desert, and we have all of these facts about why the county has enacted a law regulating land use to require preservation in their normal condition of washes in desert areas. All right, so we've got an environmental regulation in the very first paragraph. We've got a plaintiff that is seeking constitutional law theories of liability. The one that comes to mind, if you've got it in your mind, is the Fifth Amendment takings issue. Whenever we've got a plaintiff who is upset about land use regulations, their lead theory of liability is going to be a Fifth Amendment taking. And it's not that common that you see a full essay question dealing with nothing other than the Fifth Amendment taking. Now, as it turns out, there's a secondary theory of liability as well, but this is truly a Fifth Amendment takings remedies question, and that's what makes it so interesting and useful. Go to paragraph 2. Here we meet the plaintiff. The plaintiff is American National Incorporated, ANI. They're a real estate developer, and they've got very specific plans to develop a 120-acre tract with 120 homes, each one on a 1-acre parcel. So it's a high-end residential real estate development company who is serving as our plaintiff. Now, take a look at paragraph 3. Here we learn the details about where the environmental regulation is likely to start pinching this development. We see that there are 2 major washes in the parcel, the great big parcel that the company wants to subdivide. And we see that 17 of the 120 lots would be suitable for building only if ANI took significant actions to preserve the washes. And these would be expensive and difficult. And so the Public Planning Commission has refused ANI's application, and the Board of Supervisors has upheld that ruling. So it looks as if we've got a regulatory taking. But let's just take a step back here and think about this like defense lawyers for a minute. The question's asking us about the plaintiffs, but as a defense lawyer, I can tell you it's always important to consider the defenses. The plaintiff has got to do it just as we on the defense have got to be very mindful about the strengths and weaknesses of the plaintiff's potential theories of liability. Now, the defense that is implied by the facts that I've just directed your attention to is a fairly unconventional one. Unconventional in that it is not a direct defense to the theory of liability. It looks to me as if this plaintiff has a long way to go before it has exhausted its administrative remedies. It looks as if this is a plaintiff that is coming to court based on preliminary decisions, not based on a final result after going through the full state bureaucracy. So, I am going to be concerned about whether or not these plaintiffs have established standing ripeness and mootness. particularly ripeness, if the dispute has still got a ways to go administratively before it really is settled what the plaintiff's problems are. Now, I grant you that we've got plenty of facts here to go to the merits of the case as well, but on a preliminary basis, I am concerned that this plaintiff has not yet established standing as a result of what appears to me a lack of a final governmental decision on the merits. I bet there are higher authorities than the Board of Supervisors, but maybe not, and we're going to have to consider the theories as well. Now, take a look at the last long paragraph right before the call of the question. This is the paragraph that turns this hypothetical into a con law remedies crossover. And one thing that you will discern from my presentations about remedies is we must always be comprehensive in dealing with all of the different possible remedies claimed by the plaintiff. And here, this paragraph tells us exactly what the wish list of this plaintiff is. And here again, thinking like a defense lawyer is going to be worth a lot of points when it comes time to actually crafting a good answer to this question. So let's look at what the remedies that the plaintiff seeks are. First, the plaintiff wants an injunction. Well, actually, we'll consider the injunction last, but we're told that the plaintiff wants an injunctive remedy, basically in order that they be allowed to develop their property. And in the alternative to an injunction, they want damages. And we know what the damages are that they are seeking. First, they want the fair market value of all 120 parcels. And you don't have to be a career defense lawyer to raise an eyebrow about that claim. We're told that only 17 of the lots are affected. Under what possible theory could the plaintiff be entitled to full payment for the retail value of the 120 parcels? Answer, there is no valid theory for that. That may be the plaintiff's prayer for relief, but it's not going to be answered in an earthly court. Next, we see that the plaintiff wants damages equal to the fair rental value of the parcels from the time they filed their application until the end of the suit. Well, again, I don't think you need to be inclined to be a defense lawyer to have a problem with the plaintiff seeking this damage remedy, because it's entirely foreseeable and reasonable that jumping through some regulatory hoops before developing 120 acres of land is completely likely. We know that developing real estate requires some interface with the government, and it's wrong to expect the government to pay damages just for the inherent delay that is a part of obtaining government approval for real estate development. So, before we organize our answer to this question, we think about the specific remedies that this plaintiff is seeking, and I don't think it's very difficult to dismiss them altogether. But for a moment, we will consider what the plaintiff's appropriate remedies would be in the event that they are able to establish a taking. And it seems to me that in the event of a regulatory taking, this plaintiff would have a fairly good claim for the fair market value of the 17 parcels they can't develop. But perhaps I'm getting slightly ahead of myself. Let's have a look at the outline of issues and see how one could best set up an answer to this challenging and complicated and difficult question. Well, first, we discuss the preliminary issues, standing, ripeness, and mootness. And I look at this claim, and my reaction from the very beginning was, it might not be ripe. The ripeness of the claim depends on whether or not there were further remedies that could be pursued out of court by this plaintiff after the Board of Supervisors turned down their claim. Now, I grant you that we're not going to just conclude case isn't ripe, goodbye, therefore no remedies. But I do think that it's appropriate always to consider these threshold issues. We've got a private plaintiff suing a government. We need to show standing, ripeness, and mootness. And it seems to me that although the plaintiff likely would have standing based on the facts alleged, I am not convinced that the case is ripe for review. Okay, fine, so we put in a couple of paragraphs about how the case may not be ripe, and then we move on. And we consider whether or not this ordinance is a taking. And we see that we apply a standard of review with regard to the regulation of land. We see that the ordinance substantially advances a legitimate government purpose. The government does have a legitimate interest in protecting the environment. It appears as if, on their face, the regulations that we're being asked to review are entirely reasonable. And also, it's quite apparent that this land use does not deprive ANI of economically valuable uses of the land. Now, I really advise you to think for a moment like a defense lawyer. And now we're going to go beyond the actual contours of what we can come up with just based on knowing the law and based on reading the question superficially. Let's go a step more deeply into defending this case. All right? We're defending this action. We're defending the regulation of this of the desert washes. And so now we represent the government. What is one of our best arguments? All right? Let me tell you. What do we tell the defense, the plaintiff, to call the lots that are adjacent to these 17 lots that can't be developed? We call them view lots. These are likely to be substantially more valuable than they would have been if all 120 lots had been developed. So now thinking really like a defense lawyer, arguing about this plaintiff's case, even if the plaintiff can establish that there has been basically a regulatory taking of those 17 parcels, on the defense we ask, has that as a whole reduced the value of the plaintiff's property? And there's an excellent chance that it has not. As is often the case, economic or actually land regulations based on the environment enhance the value of property that is adjacent to the protected land. And so even if the plaintiff does have a colorable claim to an administrative taking of the 17 lots that can't be developed, that claim probably would be at least to some extent balanced against the increased value of parcels that are adjacent to the undeveloped parcels. So, as you can see, my hostility to this plaintiff's case is fairly comprehensive. Basically, I don't believe that they are ripe for review because they haven't gone all the way through the appeals process. But even if they have, even if the Board of Supervisors is the final word and we have to judge this case on its merits, I'm not satisfied that the plaintiff has established damages because the regulations put forth by the city or by the locality is unlikely to constitute a taking when we view it as a whole. Now, suppose you are not like me. Suppose you are inherently a plaintiff's lawyer and you know you're going to have a long career on the side of the plaintiff. Well, you had best be well advised to think a lot about the defense, because one of the most common mistakes made by plaintiffs' lawyers is to overvalue their cases by having too much of a heart connection to their clients and not being dispassionate enough. And a dispassionate review of this situation, even from the point of view of the plaintiff, must show that this is not a very strong case. So now we directly address the remedies that the plaintiff is seeking. They want the full market value of the 120-acre parcel. Well, it doesn't take very long to dismiss that claim. They want the full rental value during the pendency of their application. Once again, it's not very hard to dismiss that claim, but we need to take the time to do it with some care. Now, we finally complete the analysis by reasoning through what would happen should the plaintiffs establish a valid taking with regard to the 17 parcels. I would suggest that the greatest remedy they could possibly get would be to be compensated for those parcels. But ultimately, in my answer, I don't even give them that, because it seems to me likely that this regulation of land for environmental preservation will end up enhancing the value of these parcels a lot more than it will decrease their value. And that wraps up a consideration of one of the more difficult con law questions you're likely to see. It's difficult because it requires us to consider a theory of liability that isn't tested that frequently. Still, having worked your way through this question, it's very unlikely that you will miss this issue in the future. Also, I think it's always useful to be very mindful of the fact that remedies can come up on just about any subject, on just about any exam. And in order to handle remedies well, the first thing you've got to do is be very specific in responding to the prayers for relief that we know about from the fact pattern. Then go a step or two further and try to think your way through to come up with the most complete, most rational approach to the final result in any given case.